Digital Personal Data Protection Bill 2022. So this bill was in news because the Ministry of Electronics and Information Technology released a draft of this bill for public consultation. So coming to the background of the personal data protection law in India, the Personal Data Protection Bill draft was first proposed by Justice Sri Krishna Committee in 2018. In 2019, making some changes, Personal Data Protection Bill was introduced in this year, 2019, and it was given to the Joint Committee of Parliament for review. So in 2021, the Joint Committee stated that more changes have to be made to meet the current technology, and thus the Personal Data Protection Bill 2019 was withdrawn. Now, a new draft of Digital Personal Data Protection Bill 2022 was passed and kept for public review. So, coming to the features of the draft. So, the first is notice and consent. So, if any online website or any online entity is asking for your personal details, they also should let you know the reason for why they are asking your details and how they will use your details. So that is related to notice and consent. Next, coming to the obligations of the data fiduciary. So here the data fiduciary is nothing but an online company or website. Okay, so under this feature, the bill imposes some responsibilities. They are, if the details taken by online entity is hacked or breached, then it must immediately inform to the board, which takes the responsibility of the data protection, and also should inform to the person whose data is collected. So here the board is also established under this bill. Okay, now coming to the second one, if deletion of personal data. So here, if the online entity's purpose of collecting data is finished, then it should delete that data. And the next is, every online website or entity must appoint the data protection officer to address data principals queries and concerns. So a data protection officer should be appointed to solve the complaints. More restriction will be imposed while processing the data of children, like to seek the permission of their parents or guardians while giving data of their children. So these are some additional obligations. And the next feature is significant data fiduciary. So data fiduciary is nothing but an online entity. Okay, so here, if any online entity is asking for sensitive data which can involve risk to a person, entity, and can affect our India's sovereignty, integrity, security, and public order, then the central government has the power to identify it and take proper action. So this is related to significant data fiduciary. Next, coming to the duties and rights of the data principal. Here, under this bill, the basic rights like right to information, right to correction or right to erasure, and grievance redressal are given. And next is establishment of data protection board. So they established, under this bill, they established a data protection board which will keep an eye to protect the personal data and any wrong entities misleading the law. And next, penalties will be imposed by the board who use the personal data for wrong purpose or send it to the other countries. So like that, the bill proposes 6 types of penalties, and the maximum penalty is of 500 crore rupees. So it is for very big entities which send the personal data and use it for wrong purposes. So it is generally for very big companies like Google and all. So next is transfer of data outside India. So this bill also notifies a list of countries to whom the online entities can transfer the personal data with some terms and conditions. So this is all about the Personal Data Protection Bill. Now look at the first box over here, the applications of the bill. So here, Under this bill, the personal data can be used within India, and if it is to be used outside the territory of India, then it should share only for trading purpose. So this law will not be applicable for offline domestic purposes and a personal data of individual that has been for at least 100 years. So these are all related to the applications and non application of the bill. Now, coming to the concerns, so there are also some concerns regarding the bill. So in this bill, they have given that after the purpose of personal data is over, then the online entity should delete it. But the bill did not tell any timeline to delete that data. And the next concern is, under the bill, they established the Data Protection Board where the complaints can be solved. And even for the board, they did not provide any timeline to solve the complaints, and it also did not specify the composition and power of the board. So, in this bill, they have missed some crucial rights like some crucial rights like right to be forgotten, right to data portability were forgotten. So these are some of the concerns regarding the bill.